All right. Today we're in the arena. What does that mean? Well, you do a lot of pre-trial stuff, and we've talked about depositions, preparing for court. But being in the arena is being trial. So we've got our Krav Maga shirt on today. We've got our black belt behind us. We're ready to fight, right? Well, it's a little bit more subtle and nuanced than that, but it's all about preparation. It's why you lift those weights. So today we're going to be talking about my top 10 tips, part one, to pick a jury to win a trial, however you want to categorize it. So I'm going to be looking at notes because there's so much I want to give you. And just if I riff off the side of my head, out inside of my head, I'm just going to waste a lot of your time, which hopefully I'm not doing with these videos. Again, Uh, these videos are for informational purpose and educational purposes, I hope. You are not my client. In this case, you're probably an attorney that is going into their own trials. And as I talk about when representing a client, either before a deposition or a court proceeding where he or she's going to have to appear, there is the accompanying stress, nervousness, and anxiety, which I've been riddled with most of my life. Most of these videos are insight to a whack job I am in my head. But I'm going to tell you today that no, it's very rare that a trial attorney is not uh, without challenges. Is without challenges, is not without challenges. We are messed up. We're trial attorneys. Why would you want to go appear and speak in public with all eyes on you, where while you think it's your client's case, there's a large part of some trial attorneys' beliefs, you're looking at one, who thinks the whole thing is a referendum on them, a referendum. Like, if you win the case, that's because I'm so great. If you lose, that's because I suck. And I'm really a big believer in how bad I suck and try to build up my self confidence as best I can. Anyway, today, enough of my nonsense. Today, we're going to talk about the top 10 ways that you can better prepare for trial. And it's all about pre trial, as I said. It's the beginning of the work that you need to do when picking a jury, because that's the first thing you're going to be doing is picking that jury. So hopefully these tips help you. But I'm going to, I hope this doesn't work against us as far as time wise. I'm going to give you two extra tips at the end. So you get 12 for the price of 10. That's a deal. Um, you don't win a case unless you win the jury. That may sound easy. Well, of course you've got to win the jury. Who else is ruling on this nonsense? Well, winning and winning over are two separate entities that, while they are mutually exclusive, also are very connected. You've got to win the jury over. And however you won a friend over, or a date, um, or even much younger, you wanted to win a parent over to see things your way to allow you to go do something or buy something. It's the same skills. It's exactly the same skills. And you already got them. So I'm going to tell you how to finesse what you got. And my first tip is know yourself, know your faults and eccentricities, and use them to your client's advantage. If you've watched me a number of times, unfortunately, see, that's one right there. You're going to notice I'm have issues with anxiety and self-deprecation. And there's also another thing. I'm a very big approval seeker, which does not work in real life if you want to function as a healthy, normal individual at trial. And that's the beauty of these eccentricities and anxieties that maybe you're riddled with or are down on yourself with. You can monetize them. You can monetize the craziness that is you. And so while I am an approval seeker, when I enter a room non-trial related, just being social, I think people are watching me. And I try to be conforming. So if there's 12 people sitting at a table, I will meet with each 12 and tell them I'll figure them out in 5 minutes and I'll conform. I guess the movie to apply is a Woody Allen movie called Village, but I'm a chameleon. That's not a good human being, technically. In trial, you want to conform to the needs and wishes of a jury that you want to say yes to your client's case, or is he or she over there? So if your eccentricity is a big approval seeker like me, that's good. You're going to do everything you can to win the jury over. Um, uh, I want to tell you a real funny story of the weirdness that is me. Again, I've said before, this is weird, but I sweat a lot in pressure situations. And I was in my very first trial, and the in the middle of summer, June, July, the electricity the air conditioning went out. It was a 13-story building, downtown Detroit, ninth floor that we're on, and it got hot fast. The air conditioner was already inadequate. So I'm in my new black suit. Gentleman that's representing Ford at the time was wearing his suit. I don't remember the color, his suit. It's relevant why I say the color. And by the way, that's a big mistake. Never wear black suits unless you're going to a funeral. Um, or things that remind the jury of funerals. If they're going to go your way, what a positive experience. So it's a new suit, and we were sweating our butts off. And the judge, who requires, that we are suited, uh, she knew it was hot, and she told the jury, "Look, I'm going to give the attorneys permission to take their jackets off. So they're going to be in shirts and ties. Don't hold that against them. Not that they would." And I remember pulling my black suit open and looking, and with a white shirt, and color had just, I now had a huge black circle about the color of this on my shirt on both sides. So the judge says, "I'm making a ruling. Attorneys, you can now take your jackets off." So the other guy starts to take his jacket off. And I'm like, "I'm good, Your Honor," because I did not want to reveal how embarrassing this was, right? That's a disadvantage. I turned it around because trying cases is no different than the stock market. It's also psychological based. And he took his jacket off. I kept my jacket on, which means psychologically, I don't feel the heat. Oh, you feel the heat? You got to take your jacket off. And now he looks like a paralegal next to the guy with the suit on. The small psychological thing born out of my eccentricities of I sweat through. I don't want to, but it's just another thing, a very positive thing that happened in that trial. I won my first trial. And how I won that first trial, not knowing anything, was I knew I had a very I had a very handsome client. And I stacked that jury with at least six. There was several women, young, good-looking women, if I may say that. Back then, you could say that. Now, I don't mean to in any way judge anybody, but both sexes were attractive. And I won that trial, maybe because I'm so intelligent, or maybe because at the end of the trial, several of them passed a message to me wanting to know if my client was single. So I knew it's a simple thing. I knew men and women and how they're attracted to each other, but I didn't know the law and I didn't know the court rules as well as I should have and I would today. It was my first trial. So you are being watched. If you're a approval seeker like me, I don't care. I love public speaking, said nobody except this guy. I love public speaking. When I'm trying a case, I'm on the edge of my chair waiting to get going. I've actually, one time I was so anxiety ridden about wanting to get going. The judge was screwing around and I finally yelled. I said, can we get started? Totally inappropriate. But I was so eager to get up there and show the world how great I am and please approve of me because I have mother problems. Uh, that I'm not afraid. If you are afraid, work it out. Your client um, needs somebody to try that case. And if it ain't you, know that early on. That's a pretrial issue. Pick a jury that matches your client. So think about your client. What do you know about your client? What are his beliefs? Is he gray haired like mine? Maybe you're going to want to put on the jury similar inclined or similar colored meaning aged hair. uh, but that is an issue too. I think trials, and again, hear me out. If you apply wokeness, whatever that is, whether you believe it or not, and I'm not taking a side, if you apply wokeness to trials, you're going to lose. As simple as that. You have to make a determination of a person in the 12 to 30 minutes you're allowed to figure someone out whether they're going to go your way. You have to say, there's a white male with white hair, and my client is a white male with white hair. That may be the connection you need, or he has certain characteristics. You have to, or it's a female. I want as many female decision makers, maybe. But it is incumbent upon you not to let societal issues, as you can't be, I'm not suggesting that you do anything wrong or improper, but you have to make determinations that will win your case. Um, in that first trial case, I would not have put parents on my jury because it's about a kid that went through in that Ford case, four transmissions, and their defense was, oh, this kid is just revving it up and killing these transmissions. An older person would a parent would go, yeah, that young kid, we do that. I wouldn't do that's a determination. Am I being ageistic or anti-age? No, I'm not discriminating. The fact is, young people said yes to this guy and I knew it. Um, so pick a jury that matches your client. You need to find out the negative too. How bad is your client? And it's called sandpapering. So in your client prep is part of tip 2, clean up that client, sandpaper that client, and in your prep, go after them, be rude, be mean, get permission from them, but you got to practice like you play. So you want someone to you want either 6 or 12 individuals to like your client. They must be like-minded as your client. That's a fact. How are you and your client dressing? It depends on the case. A large majority of my cases, I'm suing debt collectors for coming after them for debts my clients owe. Uh, so I don't want me or my client wearing $1,000 suit or really good looking stuff and then claiming I don't owe a couple of $1,000 because I can't afford it. So respect the jury and the court, dress nicely, but I always have my rattiest suit, not a bad looking suit, just something that doesn't say, I don't have a pocket or a handkerchief. I just think that is a rich thing, and that's just me. Simple tie, simple shirt, simple suit. Um, here's a tip. What's on your table? At court, what do you intend to put on your table? I have books of that show that I like to help people, that I'm interested in justice for consumers. My book may tip off the jury how I feel, but that's a message they're hearing. But I like to have books that show who I am. I'm there for consumer justice. That's why those books are right there. Tip off to the jury to who you are. Um, I used to put pictures of my kids right on the table that I sat in front of the jury. I wanted them to see that. But I also, on a larger scale, wanted me to see that so I knew why I was sitting in that jury room, in that courtroom for 5 days straight. You're doing it for my kids. So you're doing it for you, but you're also tipping off the jury that you're a good family guy. And if he or she doesn't have pictures like that, they can, in their mind, assess, well, this guy doesn't really care about his family if they want. Again, this is another thing. It's an inch, but inch by inch, things add up. Um, Colors matter. You can actually read a book. I think it's called Malloy's Dress for Success. It's a 20, 30-year-old book. I remember reading it and I learned that blue is the color of success. Let me repeat that. Blue is the color of success. In fact, you want to see when you're driving, next time you're driving somewhere, take a look at most of your big banks or large companies. Take a look at what color is their building. It's blue. That's not an accident. And again, I live by my $200 suit theory, which is don't wear a $1,000 suit to a debt collection case. Um, it's probable, usually if we're going to trial, somebody's trying to teach me a lesson or my client a lesson. And so they probably got three attorneys on the other side. I've actually been in trial once. I had such a big case. I was the only person in the courtroom on my side, and there were 20 attorneys on the other side. They had to get extra chairs, and just the appearance when the court says, make your appearances, it took 15 minutes. So I moved my chair as far away from that mess so that I would be individually seen as opposed to 20 massive people with their sometimes conflicting fights. I would let them work it out and I'd point it out. What's going on over there? There's so many things that you can do for your case, knowing your case. Um, Again, as I said, I knew nothing when I tried my first case. Judge was so mad at me at one point that really happened because I sucked. I don't know what she was thinking, and she actually got voted to the Court of Appeals, not because of me, and she got sick of me and threw a pencil at my head. That happened. I was already nervous, and they shipped in about 20 or 30 people on the Ford sides, and every time I'd make a mistake, which is often, they kind of cheered. And the judge was friends with the other side, the other attorney, and she made it obvious. Um, it was really tough. Um, so as I said before, you gotta roll with it, man. You gotta have thick skin, and you just gotta go for it and make your mistakes. But preparation is how you win. The pre-trial preparation and knowing how to pick a jury, knowing how to clothe yourself, knowing how to clothe your client. Here's a really good tip, and I use this tip. A couple of trials after my first trial, I always told my clients, when you leave the house, everybody you see from here on in is on your jury. What do I mean by that? What if you're going to, because you're going to the same places a lot of juries on jury day when you're picking a jury. There's over 100 people going to your courthouse because there's several trials to fill in, and to pick. You can't just have 12 jurors and hope that you don't throw anybody off the jury. You got to have lots of them. So there's a lot of people all going your way. I tell my clients, every person you're going to meet that day is on your jury. Why? So they don't piss anybody off. If they cut anybody off or flip someone off in their car, I can tell you, I once arrived for court in a parking lot next to this huge car, and this poor old lady is just standing there hovering over the car. And I had to get to court. I was late, and I couldn't pass the lady. I still do it today. I can't let anybody. eh, It's approval seeking. So I said, "Ma'am, I've got bags and things. Can I help you?" She goes, "Yeah, my car won't start." So in my suit, fortunately, it was a $200 suit. I got in her car and got it started, and then I said, "You going?" She goes, "No, no, I just need to know it starts when I leave." And all right. So off I race. Guess who's in the jury pool? That's right, that lady. Wasn't doing it for that reason, but that's an example. Um, that happens, especially if you're in the parking lot of the courthouse you're about to enter. There's a chance. Why else are those people there other than administration or other cases? There's a good chance that person that you're helping is a possible potential juror member. So another pre-trial tip. Don't have your client talk to you in trial is another tip. You want to prepare your client that he or she is not to talk to you. Why? Because I'm so great. Don't look me in the eyes. Don't talk to me. No, because clients will say the darndest things. I got stuck in trying a case in a shoebox once. This room is really small. It could have been the place I was in. So I could touch a juror if I wanted to from where I was sitting. So that means they were hearing everything. And my client said to me, "I don't like juror number 6. She's blah, 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 blah." Well, juror number 6 is now not going to be on my jury. And you've only got so many preemptories, and we'll talk quickly about that soon. So I have my clients write on a pad. Do not talk to me during the trial. Write to me. Now, a good thing about having your client right next to you as you're picking a jury is this is a team effort. So as I'm focusing on juror number 7, okay, tell me all about yourself, yada yada. Maybe juror 12 is looking at me like, he's not liking me. He's scowling at me. Or juror 11 is like laughing at my jokes. If you get someone to laugh at your jokes, um, that's a good sign. So I'm not seeing that because I'm focused on number 7, let's say. Or he or she, your client, is writing notes to you. "Hey, juror 11 really liked you." And I look over and she's still looking at me. Boom. I just got a new set of information, intelligence that I would not be able to obtain my own because if I'm doing a good job on juror number 7, I'm not focused on 11 or 12. So use your client with the notepad to pass you messages in picking, frankly, their jury. It's their case. And also, they're also telling you that when they pick or look at a juror and whether they like them or not, they're saying, I don't have anything in common with that person. So they're doing if you will, the discriminatory work for you within the context of picking a jury. Tip number 5, I'm not being as sequential as I can be. By the way, on my website, electionstopper.com, will be the show notes. I always write a couple of pages of notes, so you don't have to go look at me again. If you just want to look at the notes, if you thought about something, hey, did Parker say that? That sounds like a good idea. Go to my show notes on my website in the section called Podcast Plus. There'll be the podcast that accompanies this video and also my notes, and it'll be perfectly delineated so you can choose. Um, and number 5 is learn your preemptories. Learn for your jurisdiction the court rules on when to use, um, how to remove a juror for cause. That is limitless. If a man or woman gets up and espouses anti certain groups' beliefs, and he's going to rule that way and your client is one of those groups that he's anti, I don't have to waste a preemptory. I think you get 3, maybe 5, depending on your jurisdiction and how large a case. And there's a time when you don't pick a preemptory, meaning if I pick a preemptory, now it's the other side's turn. They then get to use their preemptory challenges. But if I don't use a preemptory, that ends it. If we got 6 or 12, we don't get to ask the other side. They've picked, you didn't pick a preemptory. And if they've got one left, now they don't get to use it. It's a skill you got to learn. And maybe and they want to, here's a balance. They want to kick a jury member that you love this person. Looks exactly like your client and it's all working. And they have one preemptory left. And you have a witness of theirs that you want to kick. You got a balance now. Do I not exercise that preemptory? Because if I do, then my opponent's going to get to exercise their remaining peremptory. Again, that balance depends on the court rules. This is kind of important. Know your preemptory reasons. You get a certain amount. Wait, just for the hell of it, you can remove someone. And you don't give an excuse when you remove someone. When you're removing a juror member, you're saying it to the court. Your Honor, would like to wish and thank the work of juror number 6, but we would like to see them depart. However, but be limiting, don't give anything away. She was looking at my client funny is not something you say, or I don't trust her. You just say, we'd like to thank and excuse juror number 7. And you're using your preemptory, you're not tipping off the other jurors that you're saying bad things or thinking bad things about them. It's a preemptory. By the way, anything you do or say will either be explained by the court or what I like to do, and because the court won't explain this, the court will explain to the jurors what a preemptory is, what is a removal for cause. But one thing you should remember, you're going to bump into these jury members in the hallways, out in the parking lot. You must not talk to them. It's not fair, it's not right, it's inappropriate. So, what one does is if you're going down the hallway and you start to see they're going to the same place you are every day, you start to see them. You can't even make eye contact. I don't make eye contact with anybody. I don't want anybody saying Parker was influencing the jury. They are told time and time again, do not talk to the attorneys. Do not talk about this case. Don't. But I always say, Judge, will you tell them, that's how I put it, they're going to think I'm rude going down the hallway. I'm not going to talk to them. I'm going to actually might even because I'm nuts, I'll put my hand to my head and not to make eye contact. Don't hold it against Parker or his client. He's just making sure he's not doing anything wrong. I'll ask the judge to give them that um, instruction, and they'll generally do that so that then I can just pass by the jury without seeming like a rude guy. You would be so surprised how many times a jury is told, do not talk to the clients out of the court, and how many times they will approach you anyway and go, hey, how's it going? How's that case going? I really like it. I don't understand people, the chutzpah, and they've been told, don't do this. You're in court. A big bad judge is, which I'm scared of, has told them, you're in trouble if you do X, Y, Z. They can't wait to do X, Y, Z. Very strange. And you've got to sit there and be a bigger jerk on, I can't talk to you. So I like that limit. I like that instruction from the court. He's not a jerk. I probably am, but he's not being a jerk to you at that time. He's not allowed to talk to you. So remember, you are being watched. Everything you do is under a microscope, going to court, in court, and when you're traveling or bumping into people, you and your client have to operate under the assumption that anybody you meet from house to court, from court back to office or house. Everybody is the jury, and just be nice. I always talk in terms of not relying on your notes, your book, your briefs in front of the judge. This is where I will sort of diverge from that advice while at the same time remaining with that. Create a trial book. Every trial attorney has their trial book, and it's the general things that you do in each trial. If you're practicing the same work in front of juries, different juries, same stuff. Like my specialty is suing debt collectors and suing mortgage companies and suing banks or any city banks or any creditors that are coming after my client. So I've got a trial book. It's my best Marco Rubio interpretation there, impression. I got a trial book that's already ready to go. I have to add certain things that are attached to the facts of my case to those things. So I'll remove things or modify things and add exhibits. Because your trial book, you have to have a trial book. If you're going to try cases, you got to have a trial book of that holds the most common things you depend on. And also there should be cases in there. If you're when you do your opening statement or you discuss witness testimony that you're in charge of or you're going to be facing and defending against, and there's a magical point, have case law if it's available and know that case law. So Parker's rule that you don't depend on a brief or a book, it's still true here. That's a form of preparation. My way of preparing for a motion is I will write out my brief and then I'll write it again. Then I'll add things and I'll keep doing that. And by the time I get to court, I know that case and I want to come off like I am not uh, reading from, I think they used to call it reading from rote. You, I'm just in it. Again, it's an eccentricity approval seeking thing. I like it when the judge or the jury can see I've memorized everything and don't need to depend on a book because the other person is going to be living in their book and it's going to follow them up to the podium. And I will point that out to the jury. I go, I've said this before in other videos. I remind them that I'm talking from my heart, representing my consumer client. I'm not a insurance attorney that doesn't take it as serious as me enough to learn what they're telling you and they have to read from a book. I'm not going to read to you because I know that's boring, jury. Um, what here's another tip. Here's a good full tip. So this is tip number the book thing, the brief thing was 7. Number 8 is exclusivity does not work here. Inclusivity does. What do I mean by that? Meaning if I'm talking to either their witness or my witness, so the jury's in its jury box. It's to the side of you, either that side or that side. Straight on is the judge, and then there's the witness box to the side. So when I talk to the witness, I'm right next to the jury. I move and go stand next to the jury. So it's me and the jury asking the questions. And when I refer to a response, I will say, why don't you tell us what you meant when you said such and such a thing? I talk about the jury as though I'm a member. I say we a lot. I say us a lot. Well, the jury and I are really confused here what you meant by that, Mr. Witness. It works. You're part of their team, and it's you, jury, and me against the big bad insurance attorney. Inclusivity. Get near the jury. The thing about approval seekers is they are big on nonverbal communication. Huge. We think everybody's watching us and we do certain things, us approval seekers, which is absurd in real life, but in trial, I'm tipping off people about me, about the way I want them to perceive me or my client. That's why you put stuff on your desk talking about you. That's why when their side says something that is wrong, I will go, oh my goodness. Like, and if I can look up and see a jury sort of commiserating with me, that's a nonverbal thing that I'm doing. I'm, yeah, me and you, right? Like, did you see that? Not like that, but if I know they're looking at me, I know because approval seekers have a freaking radar, man. I can tell you everything everybody's doing in a room. It's weird, but that is serves me well. So I can pretty much see when I'm sitting there how a jury's reacting to what Mr. Smith is saying. And if I see them kind of, oh yeah, that's good, then that note goes down. Destroy Mr. Witness's last statement in front of the jury. And so that goes back to tip number one, know yourself, be self-aware, know your eccentricities and monetize those. Do good for your client with your weirdness. That's what I do. Um, I've given you instructions when when it's your first motion or first court appearance, or even if you've been doing this for 10 years and you haven't been doing what I'm about to say, go to a court, preferably with this judge, beforehand and sit in a trial. How's the judge handling witnesses? Um, sometimes the case rests on the jury pick and the people you pick for a jury. And a subset of that is this bothered the heck out of me the first time this happened to me. I've prepared to pick my jury with questions I need to ask them. Now, my questions don't say, tell me how you feel about debt collectors. It's how I'll go, how put your hands up. How many people have been harassed by debt collectors? All right. It's the same question, but it's self-serving for my client. How many people just had enough of the phone calls, constant phone calls like my client, Mr. Smith? That maybe I'll get yelled at by the judge, but your questions have to be selling your case because get ready, always be closing. Your discussions when you pick a jury, when you prepare what you're going to say to the jury, should be self-serving. Do you think it's right that a debt collector can call you at work and cause you to get in trouble at work, like what happened to Mr. Smith? Show of hands who think that's okay. Well, no one's putting their hands up. And if they do, off with their heads. They're not being sitting in my jury if I can help it. So we want to self-serve our questions to the jury. You have to prepare for that. Um, that number nine's tip is go to, like I said, go to a trial with this judge. And where I was going with that is the first time this happened to me where a judge informed both of us, I'm handling the picking of the jury, meaning she was gonna ask the questions. And judges will do that because they want to move this case along. And by the way, there are some court judges where they just leave you alone. There are other judges where they're all up in my grill. They're just every part of. I've been in what's called micromanaging judges, where I admire the brain, but I like to argue my case my way. That's my right. And a micromanaging judge is not going to be good. So go find out if the judge is micromanaging and has to be involved in every part. Why? Because I don't want to be learning that the first day and trying to figure that out. I want to learn it a week before I go pick my jury. And if the judge is going to pick the jury for me and ask the questions, I need a motion, hoot sweet, saying, I want to ask the jury, or if the judge is going to do it, here's the questions I want asked. So I've asked the same thing, but what I've done, I've given the judge a chance to say no and then yes, but I get whatever either way. If I can't ask the questions, and he says, no, you just give me the questions you want asked, and the other side, either way, I've won. I just need those questions asked. What I can't do is do self-serving stuff like, were you harassed like my client? So that nuance is not going to be in the question, but at least I get better than the judge's perception of what needs to be asked. So how do you learn all that? Go to watch a trial by that judge. It's a little bit of work, but as I preached in my deposition, take the time and you'll spend less time in the long run. So, again, I talk about the great unknown and the nervousness of not knowing something. Going to trial prior to the trial you're actually doing, you're going to learn so much. Knowing, controlling is a great way to cure nervousness and anxiety. When I know I've got enough knowledge, I get excited. Oh, I can't wait to do this, knowing that the other guy has no clue what's about to happen. And these small things will add up to victory. As an expression, inch by inch, anything's a cinch, and it's true. Those inches become feet, and those feet put you miles ahead of the other side. When you take a hit, um, I want you to respond. Uh, this girlfriend that was a flatliner, she didn't get excited. She didn't care if something negative happened. And it didn't work. There was no emotion there. You kind of have to be a flatliner, which it didn't work in person to person communication in that case, in that relationship. But in court, things that don't work in personal relationships are perfect. You want to be a flatliner. You're going to take a hit where you're going to lose or make a mistake in front of the jury. Keep your head down or don't be a jerk about it. Also, when you win a good point, don't be a jerk about it. Don't show emotion. I want you to flatline. The only time I want you to react is if, again, you're sending an approval seeking message to the jury. They do something goofy and you just want to have this look, can you believe these guys? But you're not doing that. You go to your client knowing your jury's watching you. Can you believe how bad these guys? Oh my God. I mean, I'm doing all this crap. You are sending a signal to the jury. That's not so much flatlining, but when you're taking a hit or when you have a success, don't be boastful, be humble, but don't be crying in your soup if you take a hit, like, because the jury may see that as, up, guess that case is done because that sucked. They don't know the importance of the hit. It may be everything, or it may be an argument over what the jury's going to see or what the jury's not going to see. Don't be mad. Thankful. Be thankful to the court. So if the court just rakes you over the coals and rules totally against you, go, thank you, Your Honor, because the jury may not know what just happened, but Parker's thanking them. I guess it worked out. He's thanking the court. So how you react, the jury, you're you may be the leading flag holder for how a jury is going to react to this case. If they see you happy about things, it must be going well. So you may want to be overly, this is an exception to the flatlining, but if something is something really important in your case, you may just want to send a little signal that says you're really happy about that. And then when you close, you'll focus on that and saying, yeah, the court ruled and it turned out that the evidence was favorable to my client. I was quite happy with that. Again, these are human beings you're talking to, and they're looking for guidance from you. Okay, now you're going to get, that was 10, believe it or not, top 10 tips. Now you're going to get an insight to me, which if you've been watching my videos, hopefully it's not too bad. But I will look for weaknesses in my opponent. I don't know how to put that, but weaknesses will show personally, not just in the case, that I will point out to the court and the jury if it benefits my client. And the only way I'm going to really show you that is after here's a good way to put it so I don't seem like too much of a jerk because I want you to trust me. I had I've had several cases where I'm suing several defendants. So the attorney or their client, who is the defendant, may or may not show. If they know that the case is going to be argued today by me, and they don't need to show because they're not going to get to do anything. Or now that side is being able to present their side of things. And because there's several defendants, one of the defendants says, well, I'm not going to go on Wednesday. I won't get to there. Maybe Friday. They won't show. So here's an example of what I do. At the right time during my closing, I will literally, and I've done this too, I'll take an empty chair. When my opponent's not looking, I'll just go put an empty chair right next to my opponent. He or she's not noticing. And then I will, in my closing, say, and this is what you should do anyway. I'd like to thank you for the civic duty. This is a great honor. I'm an immigrant. I understand how great America is. And all it asks is that you pay an entrance fee, which is obviously pay your taxes, but for doing business here. But you are asked to do a few civic duties for this great nation of ours. And I truly believe that, by the way. So, and you got to believe what you're saying or don't say it because we're humans and we can see right through the BS. So, um, I'd like to thank you today, jury, for showing up, doing your civic duty. I know you sacrificed time with your family and your kids, and you had to look at this face every day. And that's a great sacrifice. You missed some jobs. But I like to point out something, and then I point to the open chair. I go, you showed up. Why didn't Mr. Smith and his client not show? Well, Mr. Smith and the client probably had a really good reason that they will, the court, the jury won't know that. And they'll go, yeah, man, I got to show up and this guy wants me to rule in his favor. It may be the thing that tips them your way. And I'll say it again. You showed up. Mr. Smith couldn't even take the time. And emotions are important, by the way. And I say that because I just felt a little something. Um, I've cried during closings. And I mean, for cases where I had no business crying. I went through this thing for a couple of years. I don't know what it was. It may have been a post-divorce or something where I couldn't stop crying during a closing. Don't hide that because it must be really important if you're crying. And it was just a symptom of something outside of the court, but I was crying. I once had my client who was 6'4", 250 pounds, and he was an owner of a RV that you went down the road, things fell apart and blinds broke. It still worked. But that was his idea of retiring, of his dream to take him and his wife. And there weren't large problems, but there were just many problems. I remember I was closing, and while he took the witness stand, I got him to cry. This big Huge guy's crying about his RV. And then I'm reporting, look, you can see he's a good guy. Mr. Smith was crying, and I'm bawling now over an RV. Well, that's who the hell I am, man. It would hurt me to fight that. And it eventually went away. And then some other weird things showed up that I took advantage of. But I'm bawling about an RV. So if you're so inclined, let it go. It's you. All right. You're getting out of a comfort zone when you're in front of a jury. You're either going to be pissed about that or uncomfortable, or you can, what I like to do, and I do this with most things, either in court or outside in the world, which bother me or scare me. I just, I've been doing this for 30 years. I lean into stuff now, whereas I'd fight it. Um, as a general practical matter in life, you should lean into things because I think it's fighting things that really causes you issues. So instead of trying to fight myself while I'm trying to cry, I just lean into it and have a good ball in front of the jury. What an idiot. Or if I'm whacked out and crazy, which is clearly obvious, I will lean into my eccentricities about approval seeking. I will seek their approval, which works in that forum, not out there in the real world. So don't be afraid. Two things in this tip, number 11, if you're getting bonus beyond the 10. If you're so inclined and mean sometimes, like me in a courtroom, because you want your client to win because that client is me. They've been through the same stuff as me. And that's a bully as far as I'm concerned. You got to be a little rude and go below the belt and point out things on the other side. You got to do it right. It's surgical because you can get slammed if you do it wrong. But that empty chair is one approach how I'll point out stuff that the jury will get. It's not Parker being mean. I'm stating fact. You showed up. Why couldn't they? Part of your pretrial prep is your opening statement, is creating an opening statement. And that opening statement should mirror your closing statement. So the work for your closing statement, which is an accumulation of everything you just went over for 5 days, mostly positive. If you've done the job, you've done the work, you've done your trial brief, you sandpapered your client, you've tried to figure out everything that could go wrong and have an answer to it. I personally prepare the hell out of cases. I learned that that's not 12 hours sitting at a desk with my butt in the same chair is not the way to go. The minute I take a walk and stop pressuring myself, things flood in. I put a piece of paper on my bedside table and I go to bed and the brain comes up with ways or things that you miss. The subconscious, and that's part of uh, the duality of human beings is they have certain beliefs depending on what part of the brain is formulating those beliefs. Stay with me. The subconscious is dealing with things and it sometimes is trying to help you, but it can't directly communicate. And your consciousness is how you deal with things. You're not to ignore the subconscious. It will give you ideas of this thing that you need to fix. Either sleep or if you stop trying to answer a problem using only half your brain, which is the consciousness problem solving part. Take a walk, look at the trees, think of something separate from your trial, and things will flood in from your subconscious. I guarantee it. Please do that. Rely on reflection and self evaluation and getting away. Go for a run, go swim is a good way to do it. Exercise. Man, I keep a pencil and pad with me at all time when I'm lifting. It comes to me. It will come to you if you just leave it alone. You got to leave it alone to get the subconscious to have its contribution. So write your opening statement. And yeah, this is tied in, knowing that if you get that opening statement being a result of both the consciousness and the subconsciousness contribution, it should look like your closing statement with some of the quirks and things that came out that you just didn't know were going to come out. You put those in your closing. So, what's the best thing to do? You're going to love this. Free trial. Have your closing statement be 10 points. Excuse me, your opening statement be 10 points. Have a box next to the point. So you won't have a trial brief that you're going to tell the opening statement to jury. This case is about how they marred my client's credit report when Mr. Billy Williams is my client's name, and it's Mr. Billy Williams Jr. They took the bad credit of Mr. Billy Williams Sr., his dad, and put it on Mr. Billy Williams Jr. credit and ruined him. Lost his job. He had a clearance with the FBI, lost that. High interest rates as a result of, and we did everything we were supposed to do to show them you got the wrong guy. They refused. So that's my case. I'm going to have 10 points that I need to prove to get that to where I've met the law. And in that case, it's called the Fair Credit Reporting Act that I have to prove was violated, the FCRA. I'll have 10 points how to do that with a box. Once that evidence gets in for number one or number six, or no, I check off that box. You don't have enough time, and you shouldn't keep repeating the same nonsense unless it's the closing, which you're going to repeat. But once you got it, get in, get out. Keep repeating what you want, obviously, but you've got a lot of work to do. You got to get to that other stuff. So check that box. Now for closing, I take that same sheet with the boxes and I write under each 1 through 10 how I got that. Number one, we found out that one of their employees forgot to put junior next to senior. So did they put it on the credit report wrongfully, or it's called willfully? Yes. And remember, Miss Smith, you write under Miss Smith testified, yeah, we screwed up. Then number two, whatever the proof is you're having a box checked off, have room for your closing that says how that evidence came in. You're doing the jury and yourself a favor because you're repeating what your opening is. If you give an opening statement and at the end your closing's nothing like your opening, you're going to mess up you and your jury. And an opening statement, look at it this way, is a promise. Promise is made, promise is kept. So your opening statement, you should write on the top, promise is made. And your closing statement, which can take you 15 minutes sitting at your table when the judge says, okay, jury, go out. They're going to give their closing, come back in 15. Promise is kept. I have said, I made some promises to you. Boom, 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 boom. It came out, and here's how it came out. Promise is kept. I kept my promise. Blah, blah, blah. I proved this. I kept my promise. Why do you do it like that instead of saying opening and closing statement? Because people identify with promises made, promises kept. You, there are great songs with their promises. Promises kept. You as a human being made me a promise, and that's what you did. Also, when you say under the box, sorry, I gotta look up how you got to the thing that you adequately proved in front of the jury, you're actually doing the jury a favor. You remember when Miss Smith said, oh, yeah, we screwed up. We put junior instead of senior. But you can see the jurors go like, oh, yeah, that's right. She did test her. You just did them a solid. So help yourself by helping the jury. So you don't want to diverge much from your opening, but remember your opening is a promise. So make sure You've done the work and know what your promise is, and then keep your promise. It's a good plan just to get through the nervousness and the monolith that in your head, at least, is the jury trial. You break it down inch by inch, anything's a cinch. Um, that was 12. I know I'm supposed to give 10. I'm going to finish this. 13, I talked a little bit about getting what you want asked of the jury. That's a thing called motion practice. You can win trials by everything I just said, but don't discount motion practice. Those are the things that are done before this thing gets to the jury. You can file motions for what the jury's going to hear or not hear. It's called a motion in limine when it gets close to the trial. And you can say, I'm filing a motion in limine to make sure um, whatever it is you want excluded, or motion in limine for us to discuss what the attorney said to their client, which is verboten and not allowed. But if you can come up with a good reason and it's good for your case, that's just an example. I don't think I've ever filed that motion, but a motion in limine says, hey, we're about to go to trial. I'd like this particular thing discussed. And they can say, no way. Well, you've done something there too. You figured out, oh, they're bothered by that. I'm making a mental and a physical note. They were bothered when I filed a motion. I got to address this and dig deeper on this. Something's bothering about that. So a motion eliminate does two things. It gets in what you want or gets excluded what you don't want if you're successful. And how someone responds to you in that motion maybe tips you off as to what they're worried about. So don't be afraid to do pretrial motion practice. Motion practice wins trials too. All right, we're coming to an end of another fun video. If you can subscribe, you can make comments. I forgot to say this on my other videos, but if there's something I missed or there's a topic that you want me to do a video on, 30 years here, I'm sure I've addressed it, done that, fixed that, and I'll put it into close to 30 minutes. So subscribe, make a comment if you want something from me. My email address is going to appear somewhere. Collectionstopper.com is where you will go for the show notes, so you don't have to go through this again. And again, I want to thank you for listening. I hope that some of this stuff helps. It's helped me. And again, very personally, it's helped me with my weirdness and my anxieties. And instead of fighting them, which cause you greater harm, I believe, I lean into my issues and apply them to my case, which, by the way, this is why I'm an attorney. They work perfectly. I got a lawnmower guy now, so I'm going to end this. Thank you very much. Subscribe, drop me a note. I hope you win your trial.